When you die, does your family have to go to court? Today, we're tackling a bit of confusion that I've been seeing over the internet lately, specifically around California's probate rules and the idea that the small estate affidavit limit has been increased to $750,000. Spoiler alert, it hasn't. There's been a major change to the law recently, specifically Assembly Bill 2016 went into effect April 1st, 2025. But unfortunately, a lot of people are either misunderstanding it, misreporting it, or just plain getting things mixed up. So today we're going to explain what exactly changed, what didn't change, and why you still may need to do some planning ahead if you want to keep your family out of court and your hard-earned money in your estate. Also, just so you know, I am planning to do a full deep dive in the AB 2016 very soon, so be sure you're subscribed so you don't miss that video. There's a lot more nuance there that we'll be covering, but with that, let's get into it. First, yes, it's true, California made some changes to probate code procedures for principal residents through Assembly Bill 2016, and for some reason made it go into effect on April Fool's Day. Now, however, if someone passes away owning a primary residence worth up to $750,000, we can use a streamlined court process to transfer that property to heirs without needing a full probate. That sounds great until you realize it's still probate. It's just a shortened version of it. We'll talk more about the reality of that in just a minute. Now, what didn't change is the small estate affidavit process under California Probate Code sections 13100 and 13101. Small estate affidavits are a tool for transferring personal property like bank accounts, stocks, personal belongings without court involvement. As of April 1st, 2025, the maximum limit for using a small estate affidavit did increase from $184,500. However, as of the time of this recording, the state of California has not yet released the new adjusted figure. We anticipate it will land somewhere around $200,000, but we're waiting for official confirmation. Once the state publishes that figure, we'll update you in a new video, so again, make sure you're subscribed. The important part for now is this. Even after April 1st, 2025, the small estate affidavit is nowhere near $750,000. If the estate includes personal property above the new threshold, whatever it ends up being, you're not using a small estate affidavit. You're heading to probate. Here's where the confusion comes from. If the estate is a principal residence valued at up to $750,000, you can use a shortened court process under Probate Code section 13151. But if it's personal property, you're still working under the small estate affidavit rules, and that cap is much lower. Again, likely to be somewhere around $200,000. Even for the principal residence though, you still have to go through probate. It's a faster version of probate, yes, but it's still a minimum 6-month process start to finish. At least $1,500 in court fees out of your family's pocket, of course, plus attorney fees if you hire legal help, which you really probably should, and if anything goes wrong, wrong paperwork, wrong assumptions, the property's worth $750,001, then you could be forced to start all over again with a full probate. In other words, it's not as simple as filing a form and walking away with title to the house. It's faster than a full probate, but it's still a headache, and it's still expensive. Again, we're going to cover the full process, risks, and best practice with the new AB 2016 changes in an upcoming video, so stay tuned for that. But keep in mind, if you go through that process, you are not selling the house until it is all done. As opposed to a probate, you can sell a house during probate. So what does this mean if you're trying to plan ahead? Well, it means you still want to avoid probate entirely if you can. That means setting up a revocable living trust, titling your property correctly, and making sure your estate plan reflects the real rules, not internet rumors. Because if you leave your estate to sort itself out, you're not saving your family time or money. You're guaranteeing they're stuck in probate court, paying court fees, waiting months at a time, maybe even losing the house if they can't carry the expenses while waiting for the court to issue orders. And for those of you with bank accounts, investments, or other personal property over that new small estate limit, You're especially vulnerable if you do not plan accordingly. So, just to recap, the small estate affidavit limit did not jump to $750,000. The $750,000 figure only applies to streamlined probate for principal residences, and you still have to go through the court. The actual small estate affidavit limit will be somewhere around $200,000, but we're still waiting for the official announcement. And probate is still a pain in the butt, even in a streamlined form. Estate planning isn't about getting lucky with the next legal update. It's about setting up something smart now while you can. If you found this helpful, please like, subscribe, and share the video with anyone you know who might be putting off their estate plan, thinking the new laws will save them, because they won't. I'm attorney Andrew Bethel, and I'll see you at our next meeting.